Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business. Jim Hart, thanks for joining me today.
Hey, thank you so much for having me, John. I really appreciate being on the show.
Yeah. So I brought you in because you are focused on trademarks, and that falls into the section of law called intellectual property, which I thought about many years ago before I realized while I could have sat for the patent bar, I wasn't that interested in actually being a patent attorney. So I left most of it behind. Now, as a business owner, it's come back around because I think about definitely trademarks a lot, trade secrets a little bit, copyright very little, and patents almost never. But I figured you would be a great person to kind of help us sort through what people should be thinking about when they start developing these forms of intellectual property.
Yeah, it's a very important topic. It's frequently, I would say, neglected topic when it comes to entrepreneurs. Entrepreneurs are kind of like jump out of the airplane and build parachute on the way down type of people a lot of the times, and they just kind of sweep these issues under the rug. But I talk to a lot of entrepreneurs on a daily, weekly basis about these issues, and so I can share a lot of what the mistakes I see people make, as well as the things that people should be thinking about if this is something that's really important for them and what they're doing for their business. So where would you like to start?
Well, I guess let's start with setting up what our terms are. Like, there are 4 types of intellectual property. We don't need to go too in depth, but enough so that anybody who doesn't recognize what those types are, they at least have a good grasp on why you'd use each.
Yeah, and this is taking me way back to my law school days, because I remember taking an intellectual property class and being so confused between the differences. And I can only imagine somebody who's never sat in a law school classroom or anything like that trying to figure this stuff out. People frequently get them all confused. But yeah, like you said, there's 4 main areas that we can talk about, and I'm just going to throw one of them out right away, and that's patents. So patents are basically, if you invent something, it could be a process, it could be a system, it could be some sort of device or something like that, you would want to register that with the U.S. Patent and Trademark Office. But you have to see a lawyer that's licensed to handle patents to do that. And I am not that lawyer. Unfortunately, I did not take the patent bar, so I cannot help people with those. So I'm just going to kind of throw that out and say, if you do need help, if you're inventing something, then you want to talk to a patent lawyer. Now, the 3 areas where I frequently help my clients: trade secrets and trademark. Now, in terms of helping you to understand what these are, I think the best way to do this is, I've got my wife's empty cup of coffee here from this morning, and this is, everyone recognizes that this is Starbucks, right? And Starbucks, name Starbucks, this logo that's on the front here for Starbucks, all of this it's basically the other, I can't pull the thing down, but the logo that's underneath here too, these are all registered trademarks for Starbucks. And the reason why this is important is because if I'm carrying this cup of coffee down the street, anyone knows where I got this cup of coffee. And this is the reason why trademarks are important, is because they distinguish your brand from everyone else. And so it's interesting. I was talking to somebody just yesterday who is developing a name for his brand, and he has this name, and he did a trademark search, and he finds that this other brand has already registered that same name. And he was really upset because he's like, well, I've already been building this business and I have this name that I'm using, but this other brand has a registered trademark, and so I'm losing all these customers to the other brand. And I wanted to just like hit him over the head and say, that's the point of the trademark, because it's protecting that other brand from you using their same name and confusing the marketplace. And that's what a trademark is. So a trademark is, it could be a brand name, it could be a slogan, it could be a logo, It could be the name of a podcast. It could be anything that identifies your business as separate and apart from every other business in the United States. And it's a federal thing. So those are trademarks. The next one is trade secrets. The best example of a trade secret is, I would say, the Coca-Cola secret recipe, right? It's under lock and key in Atlanta. Nobody can get to it. The only people that know it are very small, probably handful of people who have access to that. And so trademarks are really important for businesses that are growing. If you have a system or a process that you're using in your business and you don't want competitors to find out about it, you certainly don't want your employees going to a competitor or leaving to start their own business and using your same system or process in what they're doing, then the way you protect those trade secrets are through contracts that you're going to enter into with clients. So a trade secret is not something you would actually ever register anywhere, but you want to make sure that your contracts that you use in your business, whether it be employees, vendors, anyone else who would have access to that information, that they can't then take that information and use it to their own financial benefit. So that's a trade secret. And that's why I say those are probably the second most important form of intellectual property. And then the third type of intellectual property that everyone frequently gets confused with trademarks are copyrights. And copyrights are anytime, like, so as we're recording this podcast, then you will be owning an immediate copyright to this, or your business is going to be owning the copyright to this. Technically, unless we had a contract in place, now mind you, I'm not going to hold you to this. I'm not going to sue you for copyright infringement. But the fact that I'm talking and I'm on this show right now, and since we don't have a contract, heads up, you probably need a contract for your podcast guests. Since I am technically a co-author of this, so I have copyright rights to this as well. So a copyright attaches as soon as that work gets published into the general marketplace. And so it protects things like paintings, music, literature, podcast recordings, video programs, whatever. That's what a copyright does. And you can register your copyright. So you could take this recording and you could register it with the Copyright Office. There's really no need to do that unless you're worried about somebody stealing it and then having to sue them. But that's why people would register their copyrights. So if you have a book or you have a sales letter that does really well, or what's another good example? Something on your website that really converts people into customers well, that has a true financial value to it, then you would want to make sure those things get copyrighted so that if somebody did try and steal that, then you'd be entitled to statutory damages and you can go ahead and sue them for copyright infringement. But again, a copyright lawsuit is very expensive. Most people aren't ever going to go through that. So I would say, unless you've got something that's really, really valuable in your business, you could be filing copyright, especially in today's day and age where people are creating content at such a tremendous pace. You could be filing copyright applications on almost a daily basis, and that's just too much for most people. So
Right.
those are the three main parts of intellectual property. And intellectual property, just as a whole, covers anything that derives from your brain, as opposed to real property, which is like land and things like that. So those are the things that I typically help clients with. Again, patents being the one area that is still very important. And I'm not going to say it's not important, but that's something that is over on its own little area that is dealt with by a special group of lawyers called patent lawyers.
Yeah. So just kind of quickly from the top, patent attorney, or to get a patent, you need an invention. It will be identified with whatever the patent number is somewhere you've registered with the Patent and Trademark Office. Copyright, you can register. Is it also going through, or where do you register those?
Those go through the Copyright Office, is copyright.gov, I believe.
Okay.
So trademarks and patents are registered with the USPTO, which is USPTO.gov. Copyrights are registered with the US Copyright Office, which is copyright.gov.
Got it. Then trademarks, yeah, there's an application for that registration process. No special certification to become a or a trademark agent or trademark attorney. If you're doing it, you're doing it. And then trade secrets, you just hide those. You don't let anybody know, because the moment they're out, then you're somewhat done for.
And that's why you need contracts that also protect against disclosure of those. So it's almost like a non-disclosure agreement that's kind of inside your employment contracts and things like that you promise not to take this stuff to a competitor or even to use it for your own benefit in your own business if you were to leave our business. So if you had a great example of that would be, John, if you have a really good process for how you bring clients in and the process that you sell them on why they need an estate plan and sign them up with your firm and then process the estate plan, and you've got checklists and you've got systems and you've got technology that you use throughout this process, and you really customize that to your firm. Those are all trade secrets that maybe give you a competitive advantage over a lawyer that's just starting out and has no idea how to get a client, how to sign up a client, how to process the estate planning documents for that client. Then you have that leg up. So you wouldn't want an associate to come in and basically steal all that stuff to go in their own firm. Now, mind you, they're going to know in their head kind of how things work, but you wouldn't want them to take your technology and steal that to go build their own firm.
Theoretically, yeah. They've learned so many things of how I use Excel, but they probably hopefully learned how to use Excel anyway.
But they would not be able to steal your Excel spreadsheet and use that as their own. They'd have to create it from scratch based on what they know in their brain.
Right. So we're here mostly to talk about trademarks, and I guess the thing that really is useful is, or a good place to start, what does it take to actually get a trademark? What does that process look like?
Oh man, you asked this question at the perfect time. I literally, just before we got on this call, I was uploading my video for the week, which is basically an ultimate guide of how to register a trademark. So it's very fresh in my mind. Not that it wasn't, I could recite it in my sleep anyway.
You've done it once or twice.
So the process, yeah, I've done it once or twice. So there's, as I was doing this video, I uncovered 8 steps to the trademark process. Now, if you look on my website, I call it the 4R framework, and there's 4 main steps, but it kind of goes deeper than that. And so the steps are, and I'll just kind of give an overview of them. You want to start by doing a comprehensive search to make sure nobody else is using your name. You want to determine who the owner of your trademark is going to be. This is very important, and it's something a lot of people mess up. You want to determine which class of goods and service and develop descriptions for all of those classes. You will need to determine what filing basis you're going to be using for your trademark, and we can talk about that here in a minute. Then you need to go to the trademark office website, and you actually need to prepare the trademark application, and you need to register, and there's all sorts of hoops that they make you go through now for privacy reasons and for verification, so the bots aren't creating applications in the trademark office website. And then once you do that and you submit your application and you pay the fees, then you have to pay attention to any office actions that may arise, which you have to respond to, and there are tight deadlines for that. We can talk about that too. And then finally, you need to go through the publication process, and fingers crossed that nobody opposes your trademark application, because that's the kiss of death. Any trademark application is if a big corporation decides to oppose it. And then the last step, the 8th one, if I got my math right there, is that your trademark will go ahead and register. And so in a nutshell, that's the process. It takes anywhere from, I'd say right now it's taking 14 to 18 months. And it's a long process. There's a lot of places where people can mess this up, but it's also very important for a variety of reasons. I would say you don't want to be an accidental infringer. You don't want to be you want to make sure that you don't start using a name and then somebody comes and steals your name and decides they're going to go register it, because then they can basically steal your name from you by registering a trademark. If they thought your name was really great and you never registered it, it's fair game for anyone to steal from you. So those are the main reasons why I think it's important to do that. But I'm happy to delve into any of those topics a little bit more if you'd like.
No, I think starting from the beginning of even just looking into what's available, knowing, go look out there. It's not just a matter of has somebody ever used this. The PTO's search function is there. It's not as terrible as you might imagine. It's also a little clunky to get used to. But
It's
when I was coming up
it
with a
is.
few, it's like, oh, is that in there? No, it doesn't look like anybody's using this. Oh my goodness.
Well, I will tell you the biggest mistake I see people make, specifically with the USPTO search function, is that they do a search for the name that they want to register, and they put in the USPTO database, and then it shows no results came back, and they're like, "Oh, hallelujah,
Perfect.
I'm good. I can go ahead and register
McDonald's.
this name." But
Got him.
that's yeah, that's not the end of the story. That's not the end of the story because it's not an exact match. That's not the standard. The legal standard is likelihood of confusion. So you may have heard of there's a delivery service for groceries called Blue Apron, and I guess Starbucks tried to register Green Apron for similar, something related to. Obviously, that makes sense. They wear green aprons, but something related to food and things like that, and they got denied because it was likely to be confused with Blue Apron. So you look at something like that; it's a likelihood of confusion standard. So if the name is similar but not spelled the same, or if it starts with the same word but then there's a second word that's a little different, or if it's a foreign translation of a US word and which is basically deemed to be in the US word, all of these things can lead to a likelihood of confusion denial. And it's based on number one, how similar the names are in sound, appearance, things like that. But then it also is dependent on what goods and services are being sold. So there are all the names could be exactly the same, but they also have to be selling related goods and goods or services. And so you have to have both those things match up. And this is where a lot of people just get confused. And they do their search and they think, oh, there's no exact match name, so I'm good. Well, that's a problem. Or they think, oh, there is an exact match name. And then they don't think to look at the services or goods that are being sold to see if they're related. And so they abandon a name that maybe they otherwise could have gotten. So I kind of see it both ways. And this is why it's really important to have counsel help you through this process because it can be really confusing.
Right. And just thinking about this, as we start to close down this interview, what are the things that advisors who have clients what should they be on the lookout for? What are the warning signs that, hey, you may need somebody to help you with this? You've got something that's worth protecting.
Well, and I think this is really important for advisors, whether they be accountants and CPAs or financial advisors or even other lawyers out there. The reason why this is important is because your clients are, if they're doing this wrong, they could be in legal jeopardy. They could be sued. I've seen people actually go bankrupt because they accidentally were infringing on other businesses and they had a lot of product or merchandise branded with their name that actually was infringing on other names. And so if you're not paying attention to this, it can be a big problem. But I would say if you're out there and you've got clients that own their own business, who are either consultants, coaches, they own retail stores, anything like that, and they've got a lot of money with you, or that you're managing for them, or you're dealing with their taxes and you can see that they own their own business. If they don't take this stuff seriously, or if they don't even pay any attention to it, it's not even a matter of taking it seriously. It's if they just are neglectful of protecting intellectual property, it could hurt the client, and then could also hurt you as a financial or accounting professional, because you potentially could have a client that gets sued for something, and that can be painful. So it, I would say anyone who has a small business that is building a brand that is not just a generic brand, that is like it has a unique name and things like that, they definitely need to be thinking about these things.
Excellent. Jim, I think that's probably a great place to end for now. For anybody who wants to follow up and find you, where can they find you on the internet?
The best place to find me is right now at jameshartlaw.com, and that will take you to my main website, but that's the easiest place to find me. And I have lots of information and resources about trademarks and all sorts of intellectual property, LLCs, all that kind of stuff. And then also, if you pay attention to YouTube, I have a YouTube channel which is Hawthorne Law, and you can actually find that with my name, Jim Hart. You just at Jim Hart, and that is my username for YouTube.
Perfect. Jim, thanks so much for stopping by.
Hey, thanks for having me, John. This is a lot of fun. I love talking about this stuff, so anytime.
Great.
Thanks so much for listening. You can find more episodes, videos, and links to more helpful content at nounfinishedbusiness.com. If you have any questions, feedback, or ideas for topics, please reach out via social media or email john@strohmeyerlaw.com. And of course, if you or your clients need help from John with an estate planning, probate, trust, or cross-border tax issue, you can book time directly with John at askjohnaquestion.com.